Hey there, I'm estate planning attorney Paul Rabalais, and in this video we're going to talk about what to do when you or a family member receives a terminal medical condition. All right, so I don't even like to talk about this topic, but I've had the opportunity to help a lot of families that have gone through it. And I wanted to make this video because I feel like if we being me who's making this video and those of you who comment below, if we can help a few folks by creating this content and sharing it and helping people who are going through it, then it's worth making the content. So I'll be the first to realize everybody's circumstances, everybody's emotional state is different when they get that terminal diagnosis. You know, some people are, dealing with estate lawyers is the last thing we want to do once we get a terminal diagnosis, and others are kind of somewhat anxious to get those legal affairs in order. So everybody's is different, but what I want to do is I want to look at a few different areas that often need to get addressed when someone's been diagnosed with a terminal condition, and kind of talk about some of the pros and cons and some of the steps that you might want to consider taking. First thing I'll go over is the various estate planning legal documents. I know that in many circumstances out there, people, when they get their estate legal affairs in order, they have to make this decision of whether they want to leave their estate to their survivors through a will or through a trust. Oftentimes, kind of my goal when I'm dealing with someone with that terminal condition is I want to do what I need to do to make sure their affairs are in order, but I don't want to do it in a way that's least intrusive on that patient. So in many cases, it's like, all right, let's get a will done. We're gonna make sure we avoid your state's laws that would govern where things would go if you passed away without a will. We're gonna state exactly what you want. We're gonna name your executor. We're gonna get that done in a couple of days. We're gonna drop everything that we're doing. And then oftentimes we get the documents to them, or they come in, or I go see them, and in a couple of days, the will's done, and they don't have to worry about it moving forward. For others, they'd rather get that trust in place. They want to enable their survivors to avoid the court and attorney involved probate process, but getting a trust in place and doing the proper funding for someone who has a terminal condition, it takes more time, it takes more effort. So there has to be that balance of, do you want to just kind of get the basics of what you need to get done, and then let the person enjoy the rest of their life, or do they want to go through a little bit more time and effort, but arrange things to avoid difficulties for their survivors? So there's that whole will or trust analysis. In addition to that, a terminal person who has a terminal condition is going to need to have all that power of attorney stuff in place. If their existing powers of attorney are very old, meaning 5, 10, 15, 20 years old, we'll want to update all of that, both the financial, the healthcare powers of attorney, to make it easy for that patient's loved ones to be able to deal with accounts, to talk to doctors, to get access to medical records, to sign things that are necessary. So getting those powers of attorney in place are really important for someone with a terminal condition. Having the living will conversation, that end of life, that life support machines conversation, it's an important conversation that needs to be had, and then the proper documentation can be put in place regarding end of life decisions and treatment decisions regarding that surround that. So that's important. And then for the wealthier folks who have received that terminal diagnosis, maybe there should be a discussion about the necessity of doing some gifting. And in our industry, we often talk about it in terms of these end of life gifts. So for the wealthier folks, getting assets out of the estate and giving them to children, grandchildren, other loved ones can often save a significant 40% or so estate tax. So that's a conversation that often needs to be had. All right. Another area that needs to be addressed is, what do you do with the financial accounts, the bank accounts, the investments? So let's talk a little bit about that. What is often a concern when you have a person with a terminal condition is if there are any bank accounts that are solely in that patient's name and that patient dies, those accounts are going to be frozen. So a lot of the conversation goes around, what can we do now to avoid bank accounts, checking accounts, savings accounts, CDs from being frozen. So there's conversations about adding authorized signers. Sometimes those conversations, if the state permits it and the bank permits it, these POD, payable on death designations, So how that conversation winds up can vary from state to state based on the state rules, and it can vary from financial institution to financial institution depending upon what they permit and what their procedures are. So, but it's something that needs to be addressed. The rules on investment accounts are very strict. You see married couples that they may have an investment account in both names, and the investment account rules say that when one spouse dies, that spouse's interest in the investment account is frozen. So you might see a couple who has a joint investment account, maybe retitle that solely in the name of the spouse who is healthy, so that when the sick spouse dies, there's no difficulty for the spouse gaining access to all of those funds. Thing with retirement accounts, IRAs, 401ks, traditional Roth IRAs, just merely want to make sure all those beneficiary designations are set up the right way. Same thing with life insurance, make sure the beneficiary designations are set up. There's perhaps some discussions that need to be had if a terminal patient has a closely held business interest. Perhaps they are a member in an LLC or a shareholder in a subchapter S corporation or a C corporation, or perhaps they are a partner in a partnership. So should there be any retitling perhaps into the spouse's name, and sometimes you have to look at the operational documents of the organization to see what's permitted, and any kind of transfer really needs to take into consideration what I'm going to talk about next. So when we talk about what do you do with the real estate, we have to be really careful. So married couples often own real estate, and sometimes if the husband, for example, gets a terminal diagnosis, he wants to make things easy for his wife, so he donates his half, especially in community property states like mine. He donates his half of the property to his wife, so when he dies, she already owns it, no difficulty there. The problem, however, with a husband, for example, who has a terminal illness, the problem with him donating his 1/2 interest in that real estate to his wife, the problem is that step up in basis when the husband dies doesn't happen, because that property was owned solely by the wife. And again, in community property states like mine, when the first spouse dies, all of the community property gets a step up in basis. That can save considerable capital gains tax if and when that surviving spouse sells that particular asset. So in taking assets out of the name of that person who has a terminal condition and putting those assets into the names of their spouse, their adult children, their heirs, you often have to weigh, okay, what's the benefits of eliminating that asset having to go through a probate versus what's the benefit of getting that step up in basis when the terminal patient who owned the asset dies. So those are real important, all need to be looked at, all need to be considered before you take any action. Then there's actions that perhaps should or could be taken with vehicles. Oftentimes couples own vehicles in both of their names. And so when one spouse dies, the surviving spouse is stuck. They can't sell or trade in the vehicle until the probate of the deceased spouse takes place. So sometimes you'll see a spouse with a terminal condition take care of that in advance by actually going to a motor vehicle office and putting the title of that vehicle into the well spouse's name only. Other than that, we want to make sure all of the important papers are handy. We want to make sure, of course, that you have the appropriate conversations with the people that you need to have them with. And then really the focus from there is just, staying comfortable and doing what you can during those remaining, what could be days, weeks, or months to stay comfortable. Now, here's what I do want to do. I don't know that I've ever really kind of mentioned this in a video before. There are some of you who may be watching this video who have some questions, and what I want to do is I want to encourage you to put those questions in the comments below. This YouTube channel has some amazing viewers and some incredible subscribers. We have a lot of professionals, whether it's lawyers, CPAs, financial professionals who comment regularly on the YouTube channel, and then we just have a ton of just all around good people who contribute by commenting as well. I know, and I can speak for all of those people to know that if you're going through a circumstance like that and you have some questions, just post it in the comments below. And if collectively this kind of YouTube channel's family, if we're given the opportunity to help you, you can kind of book it. Either me or those others who view and subscribe to this channel will, given the opportunity, contribute any way we can, answer those questions, hopefully provide you with some comfort and some peace of mind. So feel free in the comments below to, address those appropriate circumstances. Okay, so hope that helps. Again, feel free to comment below, and we'll see you next time.